what he's doing to my kids is not okay.
I'm paying $300 a month for childcare that I don't think that she's going to.
This matter is before the court on the defendant's motion for custody. Ms. Hall, I note you've stated in your motion what you want. However, the court will note that there was a judgment of divorce entered just weeks ago on September 27, 2023. You have to show a factual or legal basis for modifying that judgment since the entry of the judgment. So what is it? What is your basis for modification or changing that custody?
So, Your Honor, back when I accidentally missed a court date because I misplaced the court paperwork. So that's totally my fault. So I wasn't able to give my side of why I should have our kids.
Okay. Let me tell you how this works. I don't want to cut you off, but you're going to get into a lot. What happens when you are modifying custody? The law states that you can only go back to the date of the last order. So you would have to establish a basis for modification from the September 27, 2023 judgment through the current date. You can't go back and say something happened 6 months ago, a year ago, or whatever, because that order resolved and, if you would, consumed all of those particular issues at that time.
Okay, so I have to, I guess I don't understand. There's no legal reason she can't be with me, so I just don't know what else I can do, because she's supposed to be living with me. Dylan and I discussed before we even got divorced that's
Okay.
how we wanted.
Ma'am, none of that matters. The judgment.
I know, I understand.
Okay, so it's from the date of the judgment of divorce forward. What is the basis for modification of that?
Dylan lied on the paperwork and said that she was in school, and she wasn't over there. She was enrolled in school over in Battle Creek, where I live with me.
Okay.
And he also lied about not having a job, and that's why my child support is so high. And also because he claims that she's in daycare, when I honestly don't know if she is or not. Last I knew, she was getting babysat by his sister-in-law because she just had a baby, so they're staying home. So I'm paying $300 a month for childcare that I don't think that she's going to.
Okay. What you can do is you can file a motion for modification of the judgment of divorce, set forth your factual basis. For instance, if it says, if you're supposed to pay childcare and there's no childcare, you can set forth that basis that he's not incurring any childcare and you're being charged childcare. So it'd be anything that would be again, a factual or legal basis for modification of the judgment.
Right. And that's what I don't know. I'm supposed to get proof of that and show you. I don't.
You have to have that, because if you set forth your factual and legal basis, he said, okay, he's not incurring any childcare. Well, his answer to the motion would be, yes, I am, and here's the person. He gets something.
He never showed proof of any of that.
Well, that's because you didn't contest the judgment at that time, and as a result, he doesn't have to he doesn't establish and provide proof when there's no objection to it.
He's lying about everything now. He's had a job the entire time, and he's claiming.
You can always bring that up in your motion to modify child support as well.
I did. Isn't this what I filled out? I'm confused on what I filled out, because that's what I went down to a friend of the court and I said, this is what's going on. Can you look into my case? And this is what they handed me for the paperwork that I needed to do. Okay.
Your motion is a motion for custody. Okay.
Okay.
That's what you, and so that's what we're addressing. Hold on. Yeah, I'm looking at your motion. I just brought it up. It says motion regarding custody. So that's what's before the court. If you want to address other issues, you'll have to file a motion and provide in your motion that these are the items that you're requesting, the factual basis or legal basis why, and then include what they call an addendum clause, which is your prayer for relief stating what you want. The only thing I have is a motion for custody. So if you file the appropriate and proper pleadings, and the court will address those at those times, because you have to give the other side notice as to what they're going to have to defend. And if you file a motion for custody, but then you're talking about parenting time and you're talking about child support and all of that, it doesn't provide them with notice of what you're requesting.
Well, my request is that she comes and lives with me, so that
I
just it'll
understand that.
figure child
I
support
understand
out.
that, and you've not set forth a basis that the court can look at to make a determination from the September 27th, 2000.
Because I want her to. That's
Well,
why. It
just
shouldn't.
because
She
you
should have
want-
never been taken from me in the first place.
Just
He
because you
took her
want
on
something
false
doesn't-
accusations.
Okay, just because you want something doesn't mean legally the court can do that. Okay, so what the court is going to do is I am going to deny your motion because you've not set forth a factual or a legal basis for the court to modify the judgment of divorce at this particular time.
My daughter wants to come live with me. Her dad is keeping both of them from me.
Mr. Hall, is there anything else that you have to add in this particular matter?
Yes, I do. Actually, I've got the proof of her being in
Sir,
childcare.
hold on. I've denied the motion, so you won the motion. So you
Okay.
do you want to argue about winning the motion?
Oh, if I won,
Okay.
then that's
Okay.
fine.
The rest, if she files another motion addressing all of those other issues she's brought up today, then you have a right to file an answer and again, to refute anything that she states, okay?
Yes, thank you.
Okay, thank you. The court will end this matter at 10:37 a.m. You're free to go. Have a good day.
Dylan Hall Senior versus Emily Hall.
I filed a complaint for divorce on March 10th, 2023. I do believe there is any possibility of reconciliation. My wife is not currently pregnant. The defendant and I have two minor children together, and their names and ages are Dylan James Hall Jr., 5 years old, Delilah Lynn Hall, 3 years old. I have read all the terms of this proposed judgment of divorce, and I agree with them. I ask this court to grant the absolute judgment of divorce. Thank you, Your Honor.
Court will find that the testimony does establish the statutory basis. There has been a showing there's been a breakdown of the marital relationship. The court will preserve the proofs pending receipt of the paperwork in this matter. Sir, have you submitted all of that paperwork to the front of the court yet?
Yes,
Yes, he does. He does have the approval. I sent you the orders, Judge.
Oh, okay, okay.
Yeah.
Didn't know I had the orders yet then. Okay, the court will enter the judgment, the UCSO, et cetera, that's been submitted in this matter. I guess I'd ask Ms. Hall, do you have any questions?
I do. It's mostly, it's not about the divorce, it's about the children. What exactly is that order pertaining to them?
Okay, you'll have to look at the judgment. There's a lot of provisions in the judgment relating to the children. So you'll have to get into look at the judgment that he provided you and decide, see what he's concluded in that judgment, because that would have all the provisions as it relates to the children.
Okay, and as soon as this is signed, I can go down and change that because I don't care. I'm glad we're divorced. What he's doing to my kids is not okay.
Well, you have a right at any point to file a motion with the court, and a motion is just a request of the court as to whatever you want. Doesn't mean you can get it just because you file it, but you can, you can submit it and ask the court for whatever relief you want, but you're going to have to file a motion, then you're going to have to serve the plaintiff at least 9 days prior to the hearing.
Okay.
Okay?
All right. Thank you.
Okay, thank you.